Well, good afternoon. My guest today is Artur Davis. Artur is a former congressman who is now a leading employee rights advocate, handling cases both in the trial and appeal court levels. In today's episode, we'll unpack Artur's approach to cases and explore what's motivated him throughout his career. Artur, good afternoon.
Marcus, good afternoon to you. Real pleasure to be a part of the trial-focused conversation today.
All right. Well, let's just jump right in at the beginning if we could. And, I want to point out to those that don't know you that you have a compelling life story. And so I want to touch on that first. So it's my understanding, Artur, that you were raised by a single mother and grandmother in Montgomery, Alabama, and you later graduated from Harvard, both undergrad and law school. So I would love it if you could tell our audience a little bit more about your early history and how that's influenced your career.
Sure. I was born too long ago in 1967 in Montgomery, Alabama, and I was raised by a mom and a grandmother. That's an experience that is all too typical for a lot of folks who may be listening into your audience. I grew up in Montgomery, Alabama, which a lot of people know as the cradle and the hub of the civil rights movement. And every now and then people ask me the predictable question, what was it like growing up in the deep South, only at that point, 15, 20 years after the passage of the Civil Rights Act? I have a vivid memory of being 10 years old, Easter weekend, the Saturday between Good Friday and Easter. My mother knew that I had become fascinated by history. So she took me downtown Montgomery, Alabama, to the state capitol. And there was this little building sitting off to the side that I was curious about. It happened to be the first White House of the Confederacy, which is where Jefferson Davis lived when he was president of the Confederate States of America from 1861 to 1865. And I remember going inside of this building. We may well have been the first two Black people who had gone inside of that building in the modern era, for all I know. And I have a very specific memory of the hostess or the curator literally giving us a tour around the building, showing us everything, showing us all of these exhibits. And to this day, I think she thought we were FBI testers at the Civil Rights Division of the Department of Justice Senate.
Right.
That's where I grew up. I went to Jefferson Davis High School, which has been renamed in the last 5 years, and got to see and experience firsthand what the American South used to be, how it's changed. And as someone who currently lives in Atlanta, but spends about half of my time in the state of Alabama and half of my time in the state of Georgia, I continue to see how this former Confederacy has now evolved and continues to change. And it's a continuing part of my life story. It's a continuing part of my work as a lawyer. And it's a continuing part of the story of our country.
One of the things I learned when I looked into your background is that at one point you were an intern at the Southern Poverty Law Center. So I'm interested about that and what impact that has had on your career.
Sure. So for those listening who don't know, the Southern Poverty Law Center is based in Montgomery, Alabama. And it was founded in the 1970s for the purpose of attacking racist institutions like the Ku Klux Klan or white supremacist organizations. Southern Poverty Law Center at one point obtained the largest verdict that had ever been obtained in a civil case in the United States against a white supremacist organization. It was a verdict that was believed to have bankrupted the Klan, at least in that incarnation. Of course, they've spun off a bunch of different corporate lives, if that's the correct term for what they are. But it's a very historic organization founded by a man named Morris Dees. They've gone on to do all kinds of work and issues beyond their initial core mission several years ago, but still an important institution in the South. And I remember when I clerked for them in 1992, I was a 24, about to turn 25-year-old lawyer. At the age of 24, you round up. So I was about to turn 25 years of age. And I got to go to Atlanta with Morris Dees to argue a case at a federal courthouse over here in Atlanta. I remember that we had to go inside of all of these buildings and work our way through these tunnels to get to the courthouse. And I remember him explaining that he had multiple death threats that he had been warned about by the FBI, including one that he would not live to collect this money. So a task that we lawyers take for granted, going to a hearing out of town, finding some place to park, and walking down the street and enjoying the nice weather as we gather our thoughts. This man had to spend that stretch of time ducking under underground tunnels to try that security had already pre-cleared for him just to get to a courtroom. It reminds me to this day of the stakes in those cases. It reminds me of what real lawyering means. For a lot of us lawyers, our idea of a rough day is we left a document back at the office and we need that exhibit, or the judge is in a cranky mood during a motion hearing. Morris Dees knew what a rough day really meant for a lawyer, and he knew about the dangers and threats that exist for people who do civil rights work. Thankfully, those threats disappeared for most people who do this work, but the importance has not gone away. The salience of civil rights work and anti-discrimination work is as acute now as it was when I ducked through those tunnels with Morris Dees back in the summer of '92.
We're going to dive into your current career in a moment or two, but leading up to that and after your time at Harvard and at the Southern Poverty Law Center, I understand that you served both as a federal prosecutor and as a criminal defense attorney, if I'm getting that right. So
Okay.
How did that inform your later career? How did that benefit or
Well,
otherwise?
I'm a big believer that to be an effective advocate, you have to fully understand how the other side views the issue. You have to be able to see through the opposite side of the lens. And when I was a young man, was a federal prosecutor, I transitioned from that to being a criminal defense lawyer. And by the way, as some lawyers watching this can relate, it's funny how you go from 100% win rate as a prosecutor to something less than 100% win rate as a defense lawyer. Funny how that happens. But that experience of litigating on opposite sides is one that I think made me a better advocate. I think it certainly is a tool that I try to take into my work now. A lot of times the practice of law involves worldviews, and certain people who practice in certain lanes tend to have a mindset about the law, about the society that we live in, even about people who inhabit the society we live in. I've never been a big fan of that kind of thinking. I've never been a big fan of prosecutors or civil defense lawyers who have a certain perspective on human beings. And I've never been a fan of plaintiffs' lawyers or criminal defense lawyers who are sometimes so zealous in their sense of mission that they don't recognize that there is another side of the narrative. I will say to a lot of my clients to this day, I want to understand your plight. I want to understand your pain, but I need you to understand that the other side, the company, the entity, the organization, the state, the county, the city, is going to have a very different perspective. I need to understand their perspective and need to translate their perspective to you so that you can be a better witness at deposition or a trial, and so that we can put together a more effective strategy. I think that those conversations go a little bit easier, and they're perhaps guided by the experience that I had all of those years ago, going from being a prosecutor to the other side of the room and being a criminal defense lawyer. I had to learn how to see opposite sides of a coin.
And I think what you're talking about translates to counseling clients and being able to, talk more realistically about their risks and benefits of proceeding or settling.
That is exactly right. When A lot of people come to the plaintiff's bar, particularly in the space I now know, employment and civil rights. There are people who've been through a battering experience. They've had an experience that's been psychologically devastating. It may be the first time in their life or career they've had a major professional setback, or it may have been a setback that came at the worst possible moment while they're dealing with a health crisis or a family crisis. But for whatever combination of reasons, a lot of people who come to me or into my firm are people who are devastated. I have to do two things. I have to relate to them. I have to have a conversation with them that understands the depth of their suffering, and that's not too strong a term. But at the same time, I have to be a candid broker of information. 90% of the cases that come to our firm, we decline for some reason or other. And when you're declining a case, you're often saying to someone, I'm not going to be able to help you, at least not in the way that you want. And it's very important that those kinds of exchanges are informed by compassion, but they're informed by knowledge, and that you convey them with a sense of compassion and with a sense of empathy.
So let's unpack your career now in employment law in a little more detail. How did you come to the practice of employment law representing employees? And if you can, how does that kind of look today? What's kind of a typical week? So if you could just kind of take us through that.
Sure. I first started practicing plaintiff's employment law and civil rights law in the late 1990s after my stint as a federal prosecutor. Went to a mid-sized civil defense firm in Birmingham. And I often say that the two stints in my life when I worked for civil defense firms are the least boring phases of my life, tying the eighth grade as singularly uninteresting things that I experienced. So I very quickly concluded that wasn't for me and set up my own practice. And in that practice, I had an unusual combination. I was a criminal defense lawyer and I was a plaintiff's employment lawyer. So I guess a true underdog's practice in a sense. And I literally remember when some of the landmark cases in the sexual harassment arena, Elliot Farragher and some of those cases first came down as a young lawyer. I was writing memos and explaining them to folks, explaining them to judges. In that phase of my career, which was by and large pre-computer, that was the era when you had to take big manila folders into library books on a shelf and pull them down and put yellow sticky pages on them. As you know, I went into public service, was a member of Congress for 8 years, was involved in public life for on and off for about 16 or 17 years, and ended up circa 2020, right before the pandemic, transitioning back into the world of private practice. And now I do 98% plaintiff's employment law. About 2% of my work is what I'll call civil rights cases. I represent a family in Birmingham, Alabama. We believe that their child was expelled from a prestigious preschool program for discriminatory reasons. I represent a family in North Georgia whose children were subjected to a racial hostile environment. We contend at their high school, and we contend the school didn't do anything to stop it. Those are civil rights cases. But the overwhelming majority of my work is in the employment space, whether it's the Civil Rights Act of 1964, race, gender, religion, sexual orientation, or the Americans with Disabilities Act, the Family Medical Leave Act. I also do some False Claims Act retaliation litigation. And it can be a very fulfilling, very emotionally satisfying kind of work to do. When I was in public service, I had the dynamic markers that you would do things that were for the greater good, and there were things that helped people, but you didn't necessarily see individual persons being impacted by your work. Well, the saving grace of being a plaintiff's lawyer, I believe, is that you do get to make a measurable difference in the lives of people. I get to get financial relief for people who need help. I get to give advice to people who need help in a very tangible way. And while it's not the broad brush systemic impact that sometimes we like to see at some points in our lives and careers. It's the enriching experience of knowing you've helped someone in real time. I know we'll talk in a moment about literally what the challenges are practicing plaintiff's employment law, but I'll start just the 30,000-foot level.
Sure.
You can't be an effective plaintiff's employment lawyer unless you have an interest in accountability and you have an interest in making sure that when organizations take adverse actions against people, terminate people, damage their careers in some way, that there is a principle of accountability. I don't have any illusion now any more than I did when I was a criminal defense lawyer that my clients are all right and 100% on the side of virtue. But I know that the world that we live in, I believe, is a better world if the employment laws and the civil rights laws are enforced vigorously and effectively. And I believe that we have a stronger legal system, effective advocates on both sides of the equation. The reality is that companies are always going to be well defended. They can afford the biggest and best law firms in our country and often have 3 to 4 lawyers working on their cases.
Right.
Plaintiffs, however, are often fighting the battle solo. They didn't have an attorney on speed dial to call when they were navigating a crisis at work. They didn't have a lawyer they could reach out to for guidance on what to put in that memo or what to say in that meeting with their supervisor, the HR director. So I view plaintiffs' work as a chance to level the playing field in a very important area of law.
Well, I everything you've said resonates with me, having done a lot of plaintiffs' work myself. And every attorney has their own approach. So I'm kind of interested in your approach to these cases. There's the whole notion of storytelling and case themes and the like. But the question is there an Artur Davis approach, if you will, to employment cases?
The storytelling part of plaintiff's employment law is probably the most critical part of it. Whether you're talking to a jury or you're sitting there at 10 o'clock at night writing a complaint that has a deadline to be filed the next day, you are first and foremost telling a story to your audience. Every good story has coherence. Every good story has a point at the beginning that makes me want to read the book or continue to watch this program. Every good story has plot development. I know there's some lawyers out there who love to organize their briefs and their complaints in this fashion that has no connection to temporal sequence. I'm not a fan of that. When we read a book, we don't skip around the book. We go from the beginning to the end. And when we read a biography, you go from the beginning to the end. I think good storytelling always does that, and legal storytelling does that. Any good story has high points. If, sort of like I'm someone who watches a lot of singing shows, and sometimes on the singing shows, I hear them talk about the importance of dynamics. If every verse sounds the same and every note sounds the same, you're not selling a lot of records. Well, if you're writing a brief or making a legal argument, if every point sounds indiscriminate, you're not catching the attention of your audience or your listener. So, and what does every good story always have? A sense of conclusion, a sense of impact. That's vitally important when you're talking to a jury. I think most advocates understand that. But it can be important when you're writing a complaint, when you're writing a brief. Storytelling, fashioning a narrative is absolutely critical. And within the 11th Circuit Court of Appeals, where I know you and I do our practicing, the 11th Circuit officially rewards storytelling. One of the doctrines that we have is called convincing mosaic of circumstances.
Right.
That's a unique metaphor that is one of the few things that's unique and novel only to our circuit. No other circuit has that metaphor, and no other circuit has that paradigm for evaluating employment cases. But what it literally means is that you're invited to assemble pieces of a canvas, hence the mosaic, pieces of a canvas that paint a narrative of potential discriminatory or retaliatory intent. And if you sufficiently fill in that narrative, if you sufficiently fill in that canvas, you're entitled to take your case to a jury. It's an interesting metaphor. It's one that some of my friends in the defense bar have roundly criticized. and it doesn't go as far as some of my friends in the plaintiff's bar would like. But I think it makes your point. It is literally saying storytelling is an essential part of proof in employment cases. And I think all lawyers who practice in this realm would do well to understand that.
You mentioned the 11th Circuit, and I've been there, as you've mentioned, more than once, handling these kind of cases. And it's interesting to kind of chat about the 11th Circuit and its approach to employment cases. And you're right, the convincing mosaic construct is one kind of unique to the 11th Circuit. Are you seeing any trends in that court in terms of their approach to employment cases? Is there any kind of sort of unified way in which they're handling it, or is it case by case? Do you see any trends there?
So I see two powerful trends, and I can utter a sentence that I would not have thought I would have uttered a few years ago. This is now an exciting time to be a plaintiff's employment lawyer. And here's why I say that. With respect to just the 11th Circuit, several opinions emerged toward the end of last year where some of the most conservative jurors on the court, such as Judge Newsom out of Birmingham, are openly skeptical of the traditional McDonnell-Douglas framework for employment discrimination cases. And I know for folks listening to this who for some reason aren't employment lawyers, I'm speaking Greek right now, but here's what that means. McDonnell-Douglas is a traditional framework the Supreme Court handed down in the early 70s for deciding whether or not these cases go to a jury. It is literally a burden-shifting framework. The obligation of proof goes back and forth between the plaintiff and defendant, and the plaintiff has to prove certain things at the outset, a prima facie case, to even move to causality. It can be very complicated in theory, can be very complicated in practice, and for years, courts have wrestled with how to apply that framework. Well, toward the end of last year, several decisions emerged, again, authored by one of the more conservative judges in the court, Judge Newsom, that openly questioned whether McDonnell-Douglas is the right framework in these cases. One opinion last December, out of the state you live in, Florida, Judge Newsom openly said that we need to be looking at one thing in these cases. Can the plaintiff prove by a preponderance of evidence that they were the victim of discrimination or retaliation? If a jury could reach that conclusion, they're entitled to take their case to a jury. That has not yet been adopted as the official rule of thumb in the 11th Circuit. McDonnell-Douglas still exists, and there have been 7 or 8 opinions since Judge Newsom authored those words that have applied a straightforward, routine McDonnell-Douglas analysis. But when you see one of the more conservative judges on the court questioning the paradigm and inviting a standard which mirrors the jury standard, when we go in front of a jury, a jury's asked to do one thing: determine by preponderance of the evidence if wrongdoing occurred. That's the case in every realm of civil law. But in the world of employment law, there's been this elaborate maze that's been constructed that doesn't resemble what a jury is asked to do. And a number of us who do this work have asked the question, why should the enterprise of getting to a jury be fundamentally different than what happens when you get to a jury? Well, to see that there are now conservative minds who are coalescing around that thought, a lot of us who practice in this field believe that before 2024 ends, we could very well see the 11th Circuit join the DC Circuit and the 7th Circuit in renouncing McDonnell-Douglas as the official standard. So add to that a big breaking news development yesterday.
I was going to mention that, but I'm interested in your take on that case.
Yes.
Right.
So yesterday, the U.S. Supreme Court ruled in a very specific context, the context of transfers within the workplace,
Right.
that you no longer have to prove that you took a reduction in pay if you get transferred. You no longer have to prove your transfer is a demotion. You no longer have to prove an economic loss. You no longer have to prove that there was a significant harm to your career. You no longer have to prove that the transfer was material. Now you simply have to prove that you suffered to use the Supreme Court's very specific term yesterday, some harm. Now, here's why that's important. While in the context of transfers, Justice Kagan's opinion analyzed the text of Title VII and pointed out that there is nothing in Title VII that creates a hierarchy of discrimination based on how badly you were damaged by the discrimination. The civil rights laws don't say if you're hurt a little bit, you don't have a claim. If you're hurt a medium bit, you have a claim, or a big bit, you have a claim. Those are damages questions to be decided by a jury, but it's an anomaly that has haunted employment discrimination law for a long time, that some victims of discrimination are told the courthouse door is closed to you because we judges objectively think what happened to you was not a big deal. Well, the Supreme Court blew all of that out of the water yesterday. And it is a very real possibility that we're going to see a world where the civil rights laws mean for the first time exactly what they say, that you cannot discriminate. You cannot differentiate between individuals and people outside of their protected class or their protected activity in any manner that affects the terms and conditions of employment. That's what, in my opinion, these laws mean to do. They mean to say you can't treat people differently for invidious reasons, but we've had a very different standard employed in the 11th Circuit, which tests the materiality and the significance of the harm. And we're in a new world as of today, and cases that are being litigated going forward now live in that world. So between the movement on the 11th Circuit away from McDonnell Douglas, which is a very pro-employer standard, and the Muldrow decision yesterday, which could one day be as fundamentally important as McDonnell Douglas has been, you can now say as a plaintiff's lawyer, it's easier to do this work now. And I know there's some on the defense side who will say, sort of what Justice Thomas alluded to in his concurrence yesterday in Muldrow, well, are we now going to see too many cases make their way in the federal court? Judge Newsom in Birmingham spoke to this very eloquently last December. And the opinion out of Florida that I mentioned earlier, Judge Newsom specifically said, let me clear my throat for a second. Sorry about that.
No worries.
Judge Newsom specifically said, actually, hold on. Should have had a glass of water if I started this and had a thing to drink tonight.
We're gonna, be fine.
So Judge Newsom specifically said, it's not the place of the courts to worry about whether too many of these cases are making their way to the jury. That's not something the courts ought to be concerned about. Courts ought not be concerned about the policy consequence of rules of law and standards that are being put in place. These statutes ought to be interpreted based on their language, and they ought to be interpreted in a way where we're not trying to have the courts act as some sort of a gatekeeper. The gatekeeping roles for policymakers. If Congress wants to change the laws to make these cases harder to bring, they have every right to do that. If Congress wants to change these laws to require a heightened level of harm, they have every right to do that. But the laws as they're currently written don't draw those distinctions. And I give judges on all sides of the spectrum increasing credit for recognizing that.
Just one last thought in this sort of part of the conversation. You talk about the 11th Circuit, but Justice Kavanaugh's concurrence in this Muldrow case is interesting, quite interesting itself, because he has the lowest bar of all. He doesn't require any showing of harm.
Yes. That is exactly right. And it's very interesting in this court that we know is now a 6-3 conservative court. Muldrow was a 9-0 decision. And one of the concurrences was exactly as you said, Justice Kavanaugh's analysis that if anything, the decision doesn't go far enough. Now, look, going forward, the circuits will have a lot of time to decide what the phrase some harm means. And there is a very real possibility that some circuits are going to lean closer to Justice Kavanaugh's view, and some are going to lean closer to what seemed to be the consensus that the court itself reached. But either way, very simple proposition. It is now easier to bring a discrimination case in the United States of America. It is now easier to say to a client that you have a discrimination claim, although you were never fired. That affects the day in, day out practice of law. That affects the economic incentives in these cases. That affects the judgment over how many resources to put into a case. And it ultimately, by changing the economics of this practice, it will mean more people practice plaintiff's employment law. It will mean, candidly, better lawyers practice plaintiff's employment law. And of course, it will mean, I believe, better results and more profit for lawyers who do this work as well.
Well, and that's a great segue into my next question or areas of questions, which is your advice to younger lawyers or lawyers new to this area of practice about the pathway forward into employment law. So what advice would you give them, if they choose that path?
So, Marcus, I'll literally tell you what I told a young lady who called me out of the blue 2 weeks ago and said she was thinking about being an employment lawyer and wanted some guidance, and she had picked me and two other people to call. First thing I told her was, if you want to practice plaintiff's employment law, you need to have a patience for people. You need to have a sense of empathy for people. At the same time, you need to know how to be candid and direct with folks whose cases are not as strong as they think they are. If you can blend those impulses and those characteristics, the ability to have a strong sense of empathy and compassion with the ability to level with people in a sensitive way that respects them, you're on your way to being a very good plaintiff's employment lawyer, because those tools have to coalesce and they have to coexist together. Another piece of advice I always give to young lawyers who are thinking about this work is, to be a plaintiff's employment lawyer, you still have to embrace the challenge. Even with everything that we've talked about with the cases that are coming down and the evolution of the 11th Circuit's thinking, the case law is still stacked in favor of companies and employers. So if you're going to be a plaintiff's employment lawyer, it requires a tenacity. It requires a willingness to get under the hood of a lot of the entities and institutions you're suing to figure out just how they work. It requires a creativity. It requires an imagination. And if for some reason those things are left out of your DNA as a lawyer, if you don't embrace creativity, if you don't embrace having to think your way around problem solving and difficult standards, this may not be the work for you. As a plaintiff's employment lawyer, success is measured by whether your client has a good outcome. As you know very well, very few of these cases go to trial. They often result in a settlement. And the tool of the trade becomes, can we put in place a remedy for our client that is fair, but yes, put some money in their pocket, that gives them some financial security as they move to the next phase in their life, that compensates them for the emotional injury they suffered, and in some cases deals with reinstatement or other specific remedies beyond money. If you can accomplish those things in about 10 pages of paper, they're the area of contract law that we call a settlement, that's often a great result. That's a great outcome. The last thing that I would say about lawyers who are thinking about going into this work, it is so critically important to write well. Every now and then I run into young lawyers who fancy themselves great wordsmiths and great orators. I would say to them, that's a wonderful tool to have. But given the small percentage of cases that go to a trial, if you do this work because you love law and order and you love watching the prosecutors make jury arguments, think about maybe becoming an actor and doing that for a living. Because in the real world of law, very few of these cases go to trial. All of these cases go to writing. Either it's the writing of a complaint, responding to motions to dismiss, responding to motions for summary judgment, writing discovery motions. The reality is all of that requires written skill. And Marcus, what is the most important tool of written skill? The ability to cogently and clearly convey an idea and to cogently and clearly marshal facts to convey an argument. If you don't know how to do that, you're not going to be a very successful lawyer, I suspect, in any realm, but particularly in this area of civil employment law. So I always love to see young lawyers come into this world. And I don't just mean people in their 20s and 30s, but even people who are new to the profession, who are mid-careers. We see a lot of people who are in their 40s now who went to law school as a second career. So they're not young to this earth, but they're young to the practice of law. And I always encourage those folks, think about civil law. It may not be, there are not a lot of TV shows based on the work we do. It's not as exciting as some other areas of law some people think, but it's very important work. And I happen to think the plaintiff side, as I've said earlier, is a very enriching way to make a difference in some people's lives.
We could go on forever with this conversation, but in the interest of time, we'll start wrapping up. And so I would love for you to tell our audience how they can contact you. And we'll put a graphic up on the screen so that they can see that as well. So how can your audience contact you to retain you or otherwise?
Sure. So my name again is Artur Davis, Artur Davis. And the best numbers to reach me are 205-881-0935 or 404-220-9165. I practice a good bit of my time, both the states of Alabama and the states of Georgia, and happy to talk to anyone who has a potential case or a potential co-counsel, or anyone who's interested in having an extended conversation about the topics we've had today.
That's wonderful. So we'll go ahead and wrap it up. And I just want to express my sincere appreciation for taking the time today and appearing on our podcast. Thank you so much.
Happy to do it. Happy to. We'll do it next time without me getting a frog in my throat for 2 minutes in the middle of it.
It was wonderful. Thanks.
Thank you.